Good evening. My name is Steve Buckley, Legal Services Counsel at NHMA. Do you want me to turn on my video? Because I can't seem to do that right now.
Just 1 second. I'll make it so that you can do that. Okay, can you start your video now?
Yeah, I can. I always find it easier for people to actually see me when I'm speaking. So welcome. Thank you for welcoming me to your Historic District Commission meeting in the city of Keene. My name is Steve Buckley. I'm your Legal Services Counsel for the New Hampshire Municipal Association. And your planner, Mari Brunner, has asked me to assist you with an introduction to some issues that might be of help to you as a commission in understanding your roles and responsibilities. And I want to thank the city of Keene for being a member of NHMA so that we can provide this type of assistance and training to our member communities, such as the city of Keene. So before I begin, I just want to say that I've got this presentation is really in two parts. The first part is really designed to give you an introduction to the issues which I think are really have to be addressed by every land use board, kind of the basics of the right to know law and some issues with regards to dealing with conflicts of interest and recusals and those issues. And then I'll get into the more important subject, and certainly that was raised by the members of the meeting you just concluded or the hearing you just concluded. What are the particulars of the statutes that govern the things that the Historic District Commission does in relation to the Historic District regulations that you have and the statutes that govern the operation of a land use board known as the Historic District Commission. So I think we're in a small enough group so that if any time you have questions, please go ahead and ask, and I'll be happy to address particular issues as we go through the presentation this evening. You should have a copy of the PowerPoint presentation that I've handed out and distributed to Mari, as well as being able to display the PowerPoint presentation here.
And I apologize, Steve, I didn't print that out for anyone. However, they are able to see your screen right now in the room.
Very good. So I again, as I said, I think that fundamental to understanding how a board operates and carries out its function for a municipality is really to understand, first and foremost, the right to know law and how that relates to the business of being on a public body, such as the Historic District Commission. Because the right to know law is fundamental to the basis of how we do local government in New Hampshire. And the Historic District Commission, as defined by the New Hampshire Right to Know law, is a public body. And consequently, it has an obligation to conduct its meetings, provide notices and minutes, and to ensure public access to the activities, both meetings and decision-making process and public hearing process that relates to how you conduct the job of being an Historic District Commission. One thing I would always want to mention and feel it's important, sometimes boards don't quite appreciate this. Even when you're having a meeting where you don't have actual agenda items on your business docket, if you just had a meeting to have a work session, even work sessions are public meetings, and those are subject to the requirement of notice to the public. The public has a right to attend and the public has a right to record, and you have to create minutes simply because that's a discussion taking place on matters within your jurisdiction. But as you've already seen, and I'm sure you've already well appreciate, when you have a public meeting and have in that public meeting public hearings, you have a certain duty to hear all the people who wish to be heard. And first and foremost, like a ZBA, now I'm on a ZBA, and I think the rules that describe the duty of a Historic District Commission are not quite as explicit as they are for a ZBA. But fundamentally, when you're hearing an application for someone seeking a building permit, because that's what you are a waypoint between someone going to the building department to get a building permit, and they can't get that building permit because they have to get this certificate from the Historic District Commission to allow the building inspector to issue the permit. So it's a waypoint. So first and foremost, of course, you got to hear from the applicant and abutters, and I think, as indicated this evening, certainly concerned citizens. So hearings have additional requirements on top of just the normal requirement. When you hold a public meeting, you have to let the public know you're having the date, time, and place of the meeting. You have to let the public attend, and you have to keep minutes of that meeting. One thing I'm sure you're already accomplishing is that the noticing of your public meetings, in most instances, is not only in two public places, but I'm sure it's widely circulated in terms of information on your municipal website. The other essential part of the right to know law, as I mentioned, is this duty to ensure you keep minutes. And these minutes are required to be kept and made available to the public within 5 business days of your meetings. Now, realistically, that means you're not going to be able to have an opportunity to meet and just go over these minutes before they're made available to the public. So you have to have some degree of trust with staff, so they will compose draft minutes that will have to be produced if requested to the public within 5 business days. And then later on, you would eventually have an opportunity, obviously, to approve those minutes. And one thing I would say about posting minutes on your website, the law now generally indicates it's the better practice for municipalities to post meeting minutes on their website. But you're not required to post meeting minutes on your website of your HDC meetings until they're approved. Now, you can post draft minutes, but you're not required to. You're only required to post approved minutes, which I think is one way to ensure that when that public facing information on your website of what you did or didn't do at a public meeting, you can have an opportunity to review those minutes before they go on the website. The other thing I want to say about minutes, certainly I would assume that you have, a detailed set of, maybe even a level of detail that almost acts like a transcript that describes what takes place at your public meetings. But that's not what the right to know law requires. The right to know law actually has a pretty narrow scope of what minutes have to have. You have to have the list of members present, the names of people participating. So someone just sitting in the audience is not a participant. You just have to have someone has to speak up. And obviously, when they do speak, you get their name recorded in the record. You have to have a summary of the subject matter discussed, decisions reached, and action made. And you also have to record the name of persons making motions and seconding motions. That's pretty much it. That's a pretty brief content requirement under the right to know law. But of course, you're a land use board, which I'll discuss in a few minutes. And as a land use board, and as someone who has defended land use boards in court, I want to have the most robust and thorough set of minutes as possible, because for a land use board, your job is not to prove that you are right. If you want to go to a superior court hearing and prove that the city did not make a mistake, what's important is there evidence in the record that supports the decision of your Historic District Commission? Superior Court judge doesn't have to agree with you. The judge just has to say, yep, there's evidence in the record that supports the decision of the Historic District Commission. But again, the reality is under the right to know law, there is this just narrow scope of what is actually required for recording in your minutes. The other thing that might occur, less so for land use boards, perhaps more likely for a city council or other boards and bodies in the city, is to have occasion to go into non-public session. Yes, it is possible for the land use board to go into non-public session, for an Historic District Commission to go in non-public session, but it has to be for a specific reason allowed under the statute. But you always, if you're going to have a non-public session, which might only be to meet with the city attorney or another attorney representing the HDC, you always begin in public. You then vote to go into non-public. You conduct the session, and ideally you then vote to come out of non-public, return to the public session, and in most instances, probably a good idea to vote to seal the minutes of the just completed non-public session. And as I indicate, I think for land use boards, the really only common reason for you to be in non-public session is to A, consult with legal counsel. So if Tom Mullins needs to come discuss with you an important legal issue and it's a confidential communication, your board has the same right to have a confidential communication, just like any other individual in the community when they're talking with their attorney. And that's actually considered a non-meeting. You don't have to have even minutes of that discussion with the city attorney. But you also have the ability to go into non-public session, even if the city attorney isn't there. The city attorney wrote you a memo or a letter. You can go into non-public session under 91-A:3, Roman 2, small letter L, to read that evidence, that legal advice from the city attorney, discuss it and go over its content. So that's all. And that evidence, by the way, that that advice could come to you by way of just a telephone call from the city attorney. So those are the probably most common occurrences where a non-public session might arise as a necessity. And these are the opportunities you can use to either have a non-meeting with counsel there or a non-public session to consider written or oral legal advice. The other thing which we feel it's important always to ensure public bodies understand is their duty to avoid substantive business discussions relating to applications and pending matters before the HDC outside of a meeting. And probably the one area which creates the greatest jeopardy for having improper meetings electronically is when you send emails to a quorum of a public body. So I'm assuming, and I'm sure this is true, the way your board operates is the way my town operates with me. I'm on the zoning board of adjustment in my community. When I get a communication about either the upcoming agenda or a packet or a site visit, the email is sent to me by the staff person. I get it from her using the blind CC method. That is, the email addresses she sends it to are all in the blind CC portion of the email program. So she sends the email out, I get it, but I can't then hit reply all and send back a communication, which goes to a quorum of the public body. And that's the thing that I think one has to be very cautious about. Sending an email as a member of a public body to a quorum of my fellow board members, because the danger is to fall and lapse into a discussion which should only be taking place at public meetings. So I think, if I could remove the reply all button from email programs for public bodies, I would probably do that. But I can't. So I always encourage using the blind CC distribution method, and caution is always warranted to make sure that you avoid issues where someone could argue you're not complying with ensuring that public decisions take place at public meetings. So I just want to stop and say that's just a brief little piece of information about the right to know law and issues that I think are of concern to the land use board, and make sure before I go on to the next subject, conflicts of interest and disqualification, there are any questions on that subject.
No, I think we're good. Thank you.
Okay, moving on then. So I just felt a need to discuss just the general concepts that deal with land use boards and conflicts of interest. And the starting point for that understanding is RSA 673:14. And I've highlighted, the key elements of the statute. And in the bold portion, you can't sit on a matter in a quasi-judicial capacity. And that's what you are. You're making a quasi-judicial decision, which is a fancy word for saying you act in the position like a judge, because your job is to receive evidence and to hear parties on two sides of a question. Like this evening, you had the gentleman who would like to demolish a building, and then you had a member of the public who perhaps had a different point of view. And you have to weigh the evidence from competing points of view, receive that evidence, apply legal standards, as was discussed. You have legal standards in your HDC regulations, and make a decision. And in those circumstances, acting in a judicial capacity, if you have a direct personal pecuniary interest, you are going to be required to recuse yourself. So if you had a business relationship with perhaps the applicant, or even a personal relationship or a familial relationship, of course, that would be a circumstance which would require you to recuse yourself. And that's the purpose behind the statute. But the other part of the statute, which is important to understand, is even though you may have gathered information in the course of your getting ready for this hearing or walking by the building, having that knowledge doesn't exclude you from making a sound decision. And I think that goes to the fact that we want involved members of the community to be on our land use boards, and we want them to bring with them their personal experience, their professional experience, and their knowledge of their community to help inform their decision making. So that's perfectly appropriate. The other thing that that statute refers to is a standard which is employed for, whether or not a member of a judicial body has to recuse himself. In this case, we're talking about the juror standard. So if you are going to be selected to be on a jury, These are the questions you're asked. Do you expect to gain or lose? Are you related to any party? Have you advised or assisted either party? Have you formed an opinion or indirectly or directly formed an opinion? Do you employ any party in the case? Are you prejudiced? Do you employ counsel appearing before the case? So these are the things you're asked. And that's the same kind of things you should ask yourself in deciding, am I so closely related to the matter at hand that I have to recuse myself? And I think the most important one is to keep in mind that you have to keep an open mind, and you have to make sure you don't have or have committed an act of prejudgment, that you're going to make your decision based upon what's going to be heard in the hearing room and the staff reports and other information which is submitted as part of the application process. A few things to mention about specific circumstances that would justify or require a judicial body member, such as a member of the HDC, to recuse himself. Obviously, if you're in a butter to the subject property, it's per se required that you would have to recuse from hearing that particular HDC application. Prejudgment is also paramount. You have to, I mean, if you were having publicly stated in either a website or a social media site or in the newspaper, your particular point of view on whether a particular building should be saved or not, and then it comes before your HDC, you've had a prejudgment, and that prejudgment would require you to recuse yourself. If you have a financial interest in the outcome, a public officer has direct personal pecuniary interest, you'd have to recuse yourself. And that's the most common one that would occur if you have a relationship, a business relationship, either with the applicant or someone who works directly for the applicant. That would be the more common one where I suppose if it occurred, an HDC member might be required to recuse himself. Employment, these are two cases that are very interesting. The Sherman versus Brentwood case, circumstance where the ZBA member was employed by the County of Rockingham in one department. He was not disqualified from hearing a case where the county was an applicant for a totally different department. So he was a member of the Brentwood ZBA, but he worked for the county. And the argument was he should have recused himself. How could he hear a case from Rockingham County when he works for the county? Well, the answer was, he didn't work for the nursing home department. He worked for an entirely different department, and it was unlikely he was going to be influenced in his decision making. Whereas the appeal of the City of Keene case, a county commissioner who was sitting on trying to decide an eminent domain matter was clearly required to recuse himself because his law partner, was representing a party to the case, and that goes directly to when you have to be recused from a jury because you have a direct professional relationship with one of the attorneys in the case. Webster versus Candia is one that I always want to mention because just because your spouse is an advocate on one side or another of a particular matter before the Historic District Commission does not mean you have to recuse yourself. So your spouse can have a different opinion than you, but it does not mean that you have an obligation to step aside because of that opinion expressed with someone in your household. McLaughlin versus Union Leader is also related to the issue of, do you have a business relationship? What's interesting about the case is there was a slip and fall case where one of the jurors had a regular relationship with actually it was not a slip and fall, it was a defamation case. Mr. McLaughlin was suing the Union Leader for defamation. And one of the jurors, it was later found out, had a monthly ad in the Union Leader for his business. And there was an argument that, he's got a business relationship with the Union Leader, he should have recused himself. And the Supreme Court said, no, an occasional ad bought in a newspaper does not make you such a close relationship with the defendant newspaper to require himself to be recused. So if you have a conflict, what are your choices? Well, first of all, you can recuse yourself. And ideally, if you have sufficient number of members who can sit and or alternates, that would fill the ability of someone else to sit in your place if you're not able to represent the city on that particular application, be a member of the HDC. You can certainly disclose for information purposes, but as part of disclosure, any land use board like the Historic District Commission, an advisory vote can be requested from the fellow members. So a member of the HDC can say, well, I've got this situation, relationship, circumstances. I'm not sure I've got to recuse myself. And you can ask your fellow board members to give you an opinion whether that's something you should recuse yourself from. But when in doubt, generally speaking, it's probably a good idea. If you have concerns about having a conflict of interest, a prejudgment, a similar basis that might justify recusal, it's probably safer, especially if you have, a person who can step up as an alternate or enough members to still render a decision. Probably when in doubt, it would probably be better to recuse yourself. So that concludes the materials I have on conflict of interest, and I'm going to move into issues relating to the direct statutory management and activities of a Historic District Commission. Just want to check in to see if there's any questions so far on those issues about conflict or disqualification. Okay, I'm not hearing any questions, so I'll move on. So let me get into more details about the Historic District Commission. This comes directly from RSA 674-45. Your job is to work on the preserving of districts which reflect your cultural, social, economic, political, community, and architectural history. And it's also designed to conserve property values in the district. Improving that historic value and ensuring those are preserved helps contribute to conserving property values. It fosters civic beauty. It certainly would strengthen the local economy, and promoting the use of historic districts, for education, pleasure, and welfare of the citizens is really a principal purpose as stated in this statute and what Historic District Commission is all about. So the Historic District Commission has very specific authority, and I think it came up this evening. You have the ability to adopt implementing regulations, which obviously you have, and or amend those regulations. But when you do adopt and amend regulations, you have to do it consistent with RSA 675:6, which is going to require a public hearing with notice, an opportunity to be heard, and before the regulations go into effect. The other thing I would say, I always want to remind people, because when I was on our planning board, if you're going to adopt a regulation under 675:6, please be sure that once it's adopted, and I'm sure it's already done, an adoption certificate is prepared by staff, signed by all the board members who voted in favor of the regulation, and do not walk directly to the city attorney or city clerk and deliver them to the city clerk, because regulations do not go into effect until they are approved, signed by a majority of the members, and delivered to the city clerk, and then they go into effect. You have this power also to administer the regulations within the Historic District Commission, as provided in 676:8-10. That its administration is part of the job of making sure those regulations are being implemented appropriately. Your historic district regulations are meant to be harmoniously part of the purpose of the zoning regulations, which are adopted by the city council. And they have to be compatible. These regulations should be compatible with the master plan and clearly the zoning ordinance. And these district commission can also, depending upon, I don't know if this is true in the city of Keene, it can also be authorized to carry on some of the duties which are conferred upon an historic, a heritage commission. Sometimes they operate concurrently. A heritage commission is really considered part of the job of the Historic District Commission. This statute, RSA 674-48, is pretty important because it makes pretty clear that this statute, the idea about historic district commissions, it is not intended to prevent ordinary maintenance or repair of any structure in the historic district. So to the extent, and I think in most instances, this is covered in the state building code, the ICC International Building Code. There are many provisions in such codes that basically say no one needs to have a permit to carry out an ordinary repair or maintenance, which there's a clear definition in there. There are certain things you need a building permit for, especially if you're doing certain electrical work, other mechanical work or structural work. But ordinary repair, and these types of activities by this statute is clearly not something that requires permission from the Historic District Commission. Then in addition, the statute goes on to say that there's nothing that prevents the construction, alteration, repair, or moving of any structure under a permit issued by the building inspector prior to the establishment of a historic district commission. So as I understood from the gentlelady who was speaking, it sounds like the city first had historic district zoning and a historic district commission starting in 2000. So if prior to the year 2000, when those went into effect, someone could still carry out these structural building demolitions and repairs without getting an HDC permit. So your historic district commission is a land use board. That's an important concept because as a land use board under the zoning and planning statute, certain mandatory things attached to how the HDC operates. But more specifically to the Historic District Commission, it is made up of 3 to 7 members decided by, as indicated here, the town meeting, but substitute city council. The city council is your legislative body. 1 member may be on the planning board and 1 member may be on the select board. In your case, I understand you have a city council member. And then 5 alternates may be appointed. One of the interesting things about the statute governing the Historic District Commission, the appointing authority, which would be the city council, has the ability to take into account the appointee's interest in historic preservation. So there's, I assume, a fair comment that a person who can demonstrate prior interest and a participation in historic preservation would have a leg up, so to speak, in being appointed to your Historic District Commission. Land use boards must, since you're a land use board, you have to have rules of procedure. Now, I don't know if these are the same things that were being discussed, but rules of procedure have to be adopted to tell how the board is going to conduct its meetings and what's going to be heard first, and what are the procedures for presenting evidence to the board, and what is the step-by-step process. Who was heard first in an application? Who was heard second? Is there a rebuttal and sur-rebuttal? Any number of things which be covered in your rules of procedure. They are supposed to be provided to the public. It could be done by the city clerk's office, but certainly having a copy at every board meeting would be appropriate. And the other thing that should be provided in your rules of procedure is when and how an alternate may participate in meetings of the land use board. It wasn't that many years ago when alternates were meant to be seen and not heard, but it was recognized it's a pretty good idea to let alternates have some participatory role so they can begin to learn how to be a member of that particular land use board. So that's the reason why this statute was amended to make clear you should put in your rules of procedure what is the ability of an alternate to participate. As a land use board, you also have certain obligations. Under RSA 676:3, the commission shall issue a final written decision which either approves or disapproves an application for a permit and make a copy of the decision available to the applicant. So tonight you made a decision. Obviously, you're going to make that available to the applicant and state the reasons why the application was approved in this instance. If an application is not approved, it is the board's obligation to provide the applicant written reasons, so they can know what are the bases upon which the board decided to say no to grant a permit. And so that person could, if appropriate, file an appeal with the Zoning Board of Adjustment. If the application is approved with conditions, the board has to include in the written decision a detailed description of all those conditions, especially if it's a condition precedent. Now, this is a little bit less likely to apply to an HDC, but again, as I recognize the relationship between the Historic District Commission and the building permit process, you're a waypoint. You know, it starts with the building inspector. Except in order to get this building permit, you got to get a certificate from the Historic District Commission to do what you want to do. So it starts the building permit application, and then the applicant has to seek your certificate. And if granted, certainly, if that is with conditions, those would be things that would be attached to the permit that would be issued by the building inspector. And this decision, I'm assuming, would be attached as an exhibit to the building permit, those conditions explaining the things that are allowed to take place with regards to construction. Then the other application decision-making process is a requirement that the conditions of approval and the description of the notice of decision has to be on file and available at the board's public file place within 5 business days of any decision. I think the most important thing that I would emphasize here, and I've seen it with many land use boards, if you're going to say no, you got to say why you're saying no. That's very important. You can't just say no, we're going to deny the variance or the application for the permit. You need to be able to explain the reasons why the application is being denied. So as I said, under RSA 676:8, your job is to issue building permit approvals. So your job is to review the applications and then assess its impacts. And so you can request reports from all these different parties: planning board, fire chief, building inspector, other administrative official, who could have information concerning the impact of the proposal on the historic district. You certainly can seek advice from professional, educational, cultural, other groups who have similar information of a nature important to the historic district that you have created through your zoning ordinance. And then ultimately your job is to file with the building inspector or other duly delegated authority, either a certificate of approval or notice of disapproval following your review and determination, just as you did this evening.
I have a question on that one.
Okay.
So like, let's say, as Russ was sort of indicating earlier, we want the planning board to include the HDC in the review process of a new building. What you're saying is that we have every right to go ahead and do that, but we don't necessarily have a right to delay or vote on anything. We just are included in the review process more as listening in.
Well, I guess what I'm thinking here is, and I don't know how you do it, maybe I can now analogize it this way. In my ZBA, what the staff does at our level, and it's a very helpful process, when we get an application in, even before our public hearing, the staff sends the application to the planning board, the fire chief, the police chief, the building inspector, and the town manager. And we call it a buck slip. And it's a simple form. It says, we've got this application, see attached. Please review and tell us whether you have any concerns or no concerns. And we get that feedback. I think that's what this is directed at, that you would be able to solicit that kind of information, ideally in time for your public hearing, so then you can take that into account. Now, I understand that there have been changes in how your decision-making relating to new construction may have impaired how you do the work you're doing now, and that you somewhat have to rely upon the planning board in trying to implement, especially as to new construction, things which are consistent with the historic district expectations you have either in your regulations or the zoning ordinance. That's a little bit different. You know, I don't know how you would go about adding those conditions, but it seems to me, you know, if someone has gotten a permit just like this gentleman did, all he's gotten is a demolition permit. But I suppose it would be a little difficult, especially if your ordinance doesn't allow you to have input on new construction. It would be hard for you to issue a permit and say, well, we're going to give you this permit to build this structure in the Historic District Commission, but we don't have any say over what it looks like. That's all going to be with the planning board. So I'm a little bit handicapped to try to navigate how do you incentivize the planning board to do things. You can certainly ask the planning board preceding your decision-making, but it's going to be hard for you, I think, to then attach conditions on how the applications will be implemented as the planning board process. I'm hoping I'm answering your question, but that's how I kind of heard it play out tonight. That's how I think it fits in here.
Yeah, that makes sense. But on the other hand, I think that we could, if we go through the proper procedures, amend the existing guidelines so that we can make those stipulations moving forward. And I know that kind of counteracts the whole couple-year process of the new form-based code, but I mean, I think we are starting to see that there is a little bit of an issue with maybe HDC oversight because of that condition. So that's just something we want to consider.
And if I may, because I think that's certainly would be for anybody that can apply, but that would be actually changing the ordinance. So it's not just a matter of changing the rules of procedures or your guidelines. That's actually would be a change to the zoning ordinance. It would have to go through that process.
It does sound like that to me here. I mean, I vaguely recall, because I'm pretty good at staying in touch with the city of Keene. I'm in the city quite often myself. My daughter lives in the city. I know I have seen the news reports about how the zoning for historic regulations changed, and there's less historic district control over new building construction. So it does sound like on that issue, it would require a zoning amendment, and that's the city council. That's not within your purview, but you do have the authority to adopt historic district regulations, but those regulations have to be consistent with the zoning ordinance. So it would probably be a little difficult to have a regulation that you would adopt that would be inconsistent with that issue in terms of building regulatory authority over new construction. But I would demur by saying, I'm not intimately familiar with your regulations or all the exact circumstances. So that's how it sounds like that how it would work. Maria, I think I hear you say something, or someone else.
I just wanted to add something to this conversation, because I think part of the struggle here tonight is that, the city did propose and the HDC did adopt new regulations that removed their authority to review new construction. And I think in this instance, though, it's really hard to review a demolition without also looking at what it will be replaced there. So just some food for thought for the commission is, you could always propose, it is a process to go through, but maybe in the instance when there's a demolition of a contributing or primary resource, you could propose that the HDC does have that authority given back to it. That would have to go, again, through city council and the whole zoning amendment process, which isn't short. I think it's a minimum of 2 months if everything lines up perfectly, but it can be done if that's something this group wanted to propose.
Right. So to continue, the procedure you have a window, and it's kind of an important window. You have 45 days after the filing of the application to agree to approve the application. And actually, as indicated in the final bullet, if the applicant doesn't give you more time, failure to file the certificate of approval or disapproval, it's going to constitute approval no matter what. So you got 45 days, and it's not, it depends on your point of view. It could be a sufficient amount of time, or depending on the circumstances, not enough time. But no building permit can be issued until you have issued a certificate of approval. But in the case of disapproval, the notice of approval is binding upon the building inspector. They can't go ahead and issue a permit anyway. They can't ignore you. So you're an important waypoint. I guess I would just say, and I'm sure you already do this, but when I was always on the planning board, because the planning board has a similar requirement, it's not an automatic approval, but if the planning board doesn't approve or disapprove an application within 65 days of plan acceptance, someone can get someone else to grant the approval, usually the city council or a superior court judge, and avoid the planning board. So if you're in a position where you need more time and the applicant's willing to work with you, get it in writing. Get it in writing that the applicant says, I hereby waive the time periods under RSA 676:9, just to be sure, you're not just taking someone's word at a public hearing. They've put it in writing and approved a waiver, but you do have this standing, limitation of time. You have 45 days to approve or disapprove an application for a certificate of approval. And if anyone is aggrieved by a decision of the HDC, they can appeal to the Zoning Board of Adjustment under RSA 677:17, and the ZBA would have jurisdiction to render a judgment. Now, I don't know how many times that's occurred, but and I would defer to Mari if she can fill in some of the blank. But if I was a member of the ZBA and we don't have an HDC in my community, I would think it'd be a little tricky for the ZBA to decide, well, how do we render a decision? Presumably, the ZBA has to take into account your regulations, the zoning ordinance, and decide, was it illegal and unreasonable for the applicant not to receive the permission, because I would assume most of the time the applicants who are going to appeal are the ones that the application has been denied. But certainly it could be those who are interested abutters who have standing to appeal, and not just any person off the street has standing. It's going to have to be someone who has a direct interest in the outcome. So it could be an aggrieved abutter. So I think my sense would be it's really the ZBA kind of standing in your shoes trying to make a decision. Was it appropriate for the board to say yes or no with regard to the granting of a particular certificate? But then if there's further matters that take place after the ZBA appeal, that will be another motion for a hearing for the Zoning Board of Adjustment, and eventually the person could adjudicate the case, whether it's the applicant or an abutter, in the Superior Court. I just have two cases, which I thought, well, the one case is probably more important than anything else. I mean, I certainly heard what was going on this evening. And, the Hanrahan case versus Portsmouth is really interesting because I think it touches on probably something you have to deal with every day. And in the two bullet points that are important is that when you make a decision, it has to be a reasoned decision. And the statute imposes a duty on you to make a group assessment of the information. And it's not just based upon the personal opinion of one or more of the members. And tonight, I mean, I was looking at the evidence. If I was just sitting in the audience, I would say, well, you had a pretty thorough engineering report. I didn't see the engineering report. You had a pretty detailed assessment of what that engineering report meant, at least from the point of view of the applicant. So I think you had pretty sound decision and good evidence to render a decision. The interesting thing about the Hanrahan case, there's two things about it that I felt were, indicative of some of the things you have to struggle with every day. And this is a situation very similar to yours. It was a bank that owned a historic property in the city of Portsmouth, and they wanted to tear down a building to build a parking lot. And they really felt that the building had no real future historic value. So what's interesting about the case is the court records what was the testimony offered. And the testimony was the applicant's attorney came in and said, we really need this parking lot. And the economics really demonstrate it's better to tear this building down than to keep it. Customer parking is really important to us. And the unfeasibility of maintaining the building really demonstrated, because of its condition, that it should be removed. And from the point of view of the attorney, the building did not have any great historic value. And then, of course, which is often the case, and I'm sure you've heard this before, the attorney said, and by the way, we're a civic-minded business and we are major taxpayers, so you should really grant this request for us. So that's the applicant's presentation. Then others testified. So there was a presentation from the director of the planning department saying, we have some real concerns about this. This is a really historic structure. And the representative of Strawberry Bank were there, the historic preservation organization. We have really big concerns about this. This is a building of historic importance. It's an Italianate 19th century structure, and they were opposing its destruction. And the Supreme Court said, in sum, it was pretty clear the commission had before it little more than unsubstantiated opinions of the permit applicant in favor of demolition, and strong information that the demolition would not preserve architectural historic settings and would in fact diminish civic beauty and value in the community. And so when that HDC granted the permit to tear down the Italianate structure, and then applicant and abutter appealed, ultimately the Supreme Court said, yeah, we kind of wonder, the board really have strong enough evidence to justify the removal decision. And I think there were a couple of things that were weighing on the board's, the Supreme Court's opinion, that the panel the HDC kind of went along with the applicant without really carefully considering the opposing point of view provided by the planning department and Strawberry Bank. And I think that's the reason why the court said in its decision, it has to reach a reasoned decision. And a reasoned decision is based upon the evidence you had before you. So if you have unsubstantiated statements by the property owner, it's not a very good building, we got to get rid of it, we need a parking lot, against strong evidence from the planning department and a preservation organization like Strawberry Bank, that's going to be a tough one to say you had a reasoned judgment to say we can get rid of the building and allow the parking lot to go up. So I think it gives you some context to understand, if someone's going to review your decision making, those are some of the things the court is looking for. What evidence did you have, and how did that evidence measure up against your duty to help preserve the civic value that we might have and want to preserve in our historic structures? So with that, I have completed the slides I have for you this evening, and I'd be happy to try to address any additional questions you might have on being a member of a historic district commission.
I have a question. Are you aware of any other municipalities that have a historic district commission that has no authority over new construction in the historic district?
Can't say I do. I've spent a lot of time advising the Somersworth Historic District Commission and a little bit advising, and by advising, I mean the NHMA. We have what's called a legal advisory service where people can contact us by telephone or email and I answer their questions. So I probably more than anyone else, it's probably the Somersworth Historic District Commission. And I just don't know enough about historic district regulations to answer that question. I don't know if you know, but the Office of Strategic Initiatives, also now known as Office of Planning and Development, they have a really cool inventory of all zoning ordinances throughout the state, including historic district regulations. And you can actually go to their website and kind of look around. And I actually had one of the planners there one time extract, for me, zoning ordinances that have certain elements. So I think it's theoretically possible to dig into that. It's called the Zoning and Planning Survey. They do it every year of all zoning ordinances. And I think you might be able to extract from that information on what communities might have a similar limitation on regulation of new construction by historic district commissions. I think it's possible to get that out of that land use survey, but I don't know if it in particular myself.
Great, thank you. Does anyone have any additional questions? Great. Well, this was actually a very helpful presentation, and I appreciate you sticking around a little bit late to present it to us.
Happy to do it. And again, I have provided a copy of the PowerPoint. So if Mari could distribute that, you could have that also as a permanent part of the materials. But you also have my PowerPoint presentations. You have that there too also. So thank you for inviting me to the city of Keene. And again, I just want to emphasize that we are available through the legal advisory service to provide answers to questions you might have either by telephone or by email.
Thank you. That's very helpful. Mary, are you able to share the contact info with us so that if we do have any questions, with avoiding deliberations outside of the meeting, that should be, heard in a public forum, but, just to have, be able to bounce back forth some questions if we have any.
Yeah, certainly. And also just to remind the board, we do have our own city attorney is also available. If you ever have any questions, he's also available and happy to answer questions by phone or email, but I can also share Stephen Buckley's information and I'll distribute the PowerPoint as well.
Great, thank you very much.